Good evening. Welcome to Land Title Talk, where we encourage you to text in your questions or comments at 904-501-4481, or you can email your comments or questions, which we can discuss on the show later on, at Stephen, S-T-E-P-H-E-N, at golandtitle.com. That's GOLANDTITLE.com. I'm Steve Collins from Land Title of America. I'll always love being here with you. And as always, I'm privileged enough to have my esteemed guest, Rusty Collins from the Law Office of J. Russell Collins, affectionately known as Rusty Law. And Rusty, what's going on in your world?
Well, I had an interesting hearing today. Back in June, I was hired to redeem a piece of property from a foreclosure sale in Duval County.
Redeem?
That's right. And
is that not too easy?
Well,
is that English? That is not too easy.
Well, it is a different kind of redemption because for some reason the clerk didn't want to take the money. At least that's what I'm being told. And so we sent them. I had the money sent that I calculated straight to the servicer. My client had the servicer's wiring instructions.
Okay. Oh, okay.
So when there's a foreclosure, there's what's called an equity of redemption. And an equity of redemption is a right in ownership of property, so that if there's a foreclosure judgment entered at any time before the foreclosure certificate of sale is issued by the clerk, the borrower or owner has the right to redeem the property from the foreclosure judgment.
Before the certificate of sale is recorded.
Before the certificate of sale is entered by the clerk into the docket.
Okay.
Okay, it's filed. Okay.
Not necessarily recorded in the public records.
That doesn't get recorded in public records.
Okay.
Now, it used to be that you could redeem before the certificate of title was recorded. But that's not the case, because the certificate of title happens, at least 10 days later. So there could be an objection to the sale. But the certificate...
That would not be a redemption, though. That would just be there was some due process that was not properly met during the foreclosure. During that 10 days.
Right. But it used to be that you could actually redeem during that time. But now you can't.
Right.
It's cut off when the certificate of sale is filed by the clerk. Now, on this particular case, the sale was at 11 o'clock. My client sent the wire transfer
but they
before
sent
8
it
o'clock.
To the freaking servicer, Rusty.
That's because the clerk said they wouldn't take it.
Since when?
I don't know. It's Duval County. I can't tell
We've
you.
done it before with Duval County.
I've never had a problem, but I think what it was, he called and talked to them. And it's one thing to take the money in to redeem. Here's the cashier's check and how we want it done.
Right.
I think it's another one to call somebody and talk on the phone.
And say, I want to wire funds. How do I wire them?
Well, you have to bring a cashier's check. There's no wiring fund.
Right.
Now, so they sent the money to the lender or the servicer. That money, I know it was sent before the wire transfer was initiated before 8 o'clock in the morning.
Okay, they initiated, but
we don't know what time it got there.
You can find that out.
Well, we've not been able to find that information yet.
Find that out in Discovery.
Now, we had a hearing today. The sale brought in, there's like $40,000 or $30,000 in surplus.
That our seller, our previous
owner could have
access to.
But that's not what they want. They want the property. So, and we're talking about a less than $30,000 redemption. The plaintiff wants
what was
to
the
have
payoff amount?
It would have been, I would think it was $22,000 and change.
Really? Okay. Vacant lot?
No.
House. Wow. House. Okay.
And
wow.
So it brought $62,200,
which would seem very normal.
Well, if the property's worth $150,000, it might be a little different, though, huh? Yeah. And there's a high bidder, and that person wants the property.
Of course.
I found out today the servicer returned the wire about three weeks later because they don't want it, which is interesting. And so we're arguing in front of the judge up there. His name is Judge Wallace. I've argued in front of him before.
3 weeks.
Yeah.
They had that money.
Right. They didn't want to take it. And in fact, they objected to our objection. Okay. Because I objected to the sale saying we redeemed. And I don't know that it's correctly stated. The plaintiff's counsel said that the money was received by that servicer at 11:50. The foreclosure sale was over at 11:06. Now, the successful bidder sent an email to Real Foreclosed, who handles the sales, and at 11:11 and says, "I'm going to the bank to get the money or to wire transfer the money." And he said it took him about 30 minutes to do that, to send the wire transfer, to initiate it. Now, we know that the clerk issues a certificate of sale when?
After the funds have been received.
After the wire is received.
From the person.
Correct.
That is the highest bidder.
Right. So, the number one, the certificate of sale is stamped, filed on a specific day, the day of the sale, but there's no time.
Why?
I don't know. Duval County. Okay? There's no time
But
stamp.
it doesn't change the facts. Because you have the facts.
Right.
Whether or not they stamped it on that certificate of sale doesn't change the facts.
Well, what time was it? If the certificate of sale was filed before 11:50, and I don't have any proof that the wire was received before that.
From the highest bidder.
No, the wire. No, if our wire was not received by the servicer before that time,
okay,
then I have a problem. Would you agree?
Okay. Yes, because when the certificate of sale, it's too late to redeem.
That's right. It's completely cut off at that time. And
the argument is, when did the servicer receive the wire?
Well, I'm pretty sure they got it around 9 o'clock, but they didn't know what to do with it until 11:50. Okay. And I don't have it. I don't have a timestamp.
It still took 3 weeks to send it back.
Well, but I don't have a timestamp as to when it was received. So now we've got the lender or the plaintiff's counsel saying, well, they got to send that money. They got to give that money to the clerk. And we're like, no, the statute says to the lender or the clerk. Okay.
Does the statute say?
It does.
To the lender or the clerk?
It does.
Does the servicer count as the lender? Dear Rusty.
Well, that's the only person. That issue is not being raised.
It's not being raised, but I'm raising it now.
Well, that's the only person you can pay because you don't. The lender's probably a trust or something. Right?
I'm just, the semantics matter, right?
Oh gosh, yes.
Okay, so that's too bad they didn't ask you for help before they paid the money, because
this was a last second deal.
Wow.
Okay, it says at any time before the latter of the filing of the certificate of sale by the clerk of the court or the time specified in the judgment, which is usually the certificate of sale being filed. Okay.
I'm sorry, you're going to have to read that again, because that did not make sense to me.
At any time before the latter of the filing of a certificate of sale by the clerk of the court or the time specified in the judgment, the mortgagor or the holder of any subordinate interest may cure the mortgagor's indebtedness and prevent a foreclosure sale by paying the amount of money specified in the judgment, order, or decree of foreclosure, by tendering the performance due under the security agreement, including any amounts due because of the exercise of the right to accelerate plus reasonable expenses.
Yes, but you said, or is it stated in the judgment? I didn't know about that piece.
Yeah.
Wait, so the judgment can say what?
The judgment is your payoff letter.
It is.
Plus interest.
Plus interest.
Plus cost of sale.
But when you read that, it says the latter of the two.
Well, the timing, at any time is the latter of the sale, a certificate of sale, or a different time if the judge says a different time. The judge is saying.
You mean as far as the sell date?
Yeah.
I understand now. Okay.
Okay. So you can redeem by paying that money. Okay. And you tender a performance due under the security agreement. And it doesn't say that you have to tender it to the clerk. or to the lender, but you're tendering performance, and where the payments go, they go to the servicer. So you can pay the servicer or you can pay the clerk. Either one works.
Okay.
Now, if you pay the clerk will stop the sale.
Right.
Okay, that makes it easy. But we weren't.
Well, and that's how we've done it in the past.
That's how we've always done it, except for this time.
We weren't involved this time.
Right. Well,
had we been involved,
if I'd been involved, well, I was involved, but I didn't have the ability to get the money and get it there.
You were involved?
I was not involved in a closing or anything. This was just a straight up redemption.
Yeah, but they would have known to take a cashier's check.
They say that the clerk wouldn't take it. I don't think they had time to get it there. I think it was easier to do. I think it was easier for them to wire.
If they wired the money, well, see, I'm arguing the screw up, but I guess that's not what we're here to argue.
Either way, we don't know when the certificate of sale was filed because there's no timestamp. Although there is a receipt at 2:05.
I see what you mean. There's no time. Well, actually, you know when it's indexed in the docket.
The date only. I don't have a time.
There's no timestamp on that docket. The court docket has 0 timestamp.
There's no timestamp on that document. Now, when we e-file stuff, we get a timestamp.
Right.
Okay. Used to be they would run it through a stamper, right?
Yeah.
And they'd go stamp, and they'd give you date and time.
Yep.
Now they just put file it. But I don't know, there's got to be a record. But anyway, so I sent it. It was interesting. The other side was arguing that, no, we didn't send enough money. Well, they filed an affidavit saying what the interest was and what the publication fee was.
You know just as well as I, the servicer versus the judgment, they never line up.
No, because the servicer wants more money. There's other stuff.
And the judge just says no.
Well, here's the problem. They had, I think they say they had force-placed insurance that accrued. But they filed their affidavit after the sale time, and that's not on there.
Judgment's rules, but you'd have to pay the clerk for that judgment to hold up. I mean, listen, you
have to pay the clerk. You can pay the
servicer. If you don't pay the servicer what they want, they've got that little asterisk, man, at the bottom of their payoff letter.
No, but we didn't say the payoff letter. This was not a payoff. This was redemption funds.
To redeem to, are you telling me?
I can redeem to the clerk or to the servicer.
Yes.
Either way.
But it was the full amount due.
No, it was
not a reinstatement.
It's not a reinstatement. It's not a payoff letter. It is the judgment.
That's what your person sent.
I told him how much to send.
But I'm telling you that there is a payoff letter. The servicer has an amount. And if you don't send that, that's going to get rejected, period.
But if it's a redemption, they don't have the right to. They may not have the right to do that.
See, what you just clarified, they may not have a right.
Well, just put it this way. Is the enough money for a redemption?
What was it?
It looked, the issue is going to be the timing of the certificate of sale. That's what we don't know. Okay.
I
think the judge agrees with me.
I don't agree with you.
We did not send a payoff. This was just a straight up wire for a redemption.
That's a payoff, Rusty.
No, it's not.
Why?
Because I don't use a payoff letter when I do the redemption with the clerk.
But you can't redeem a mortgage.
Sure you can. We're not redeeming a mortgage. We are redeeming the property from the foreclosure judgment. We're paying the judgment, not the mortgage.
Then you have to pay the clerk.
No, you don't. Not according to statute. Not according to case law.
We do not have time to have you look it up and argue it.
Well, I know, but this is something I don't even have to look up. You can give it to the lender, or you can give it to the clerk. Now,
no, the lender can reject it, Rusty. We know very well. We have experience with this.
No, but
lender, judgment.
Mm-hmm.
They're not the same. Lender's going to insist on this amount, even to redeem. They're gonna want this amount.
Right.
Period. You don't send them that amount, they reject it. Period. There's no argument there.
But the question,
and they have every right to do that.
That's
yes,
not true.
They do.
I didn't.
Do you have case law?
Letter.
Do you have case law that shows where a judgment supersedes what a lender's payoff is?
Well, what's the lender's payoff based on?
Their evidence and facts. They have.
No, they're based upon what? The mortgage.
No, their documentation. Their record keeping. Yeah.
They don't exist anymore.
I think you're barking up a tree that doesn't have any squirrels in it.
You want to wash my car?
Yeah. If you don't know what that's in reference to, that's because I made a bet with my brother a long time ago. And he won.
Bet that,
No,
that
you don't have to
OJ
say.
was going to be
You
convicted.
didn't have to say what it was. I thought for sure OJ was going to be convicted. He was later.
Just because he did it doesn't mean he got convicted.
Well, he was
Not the
convicted
question
later of
something else.
being liable,
He was found liable.
financially liable.
That's right.
We digress. But I don't believe that a lender servicer has to allow a third party like you or some borrower to send them money and say, accept this or else. It ain't going to work. You have to get
Based upon what? The law says I can redeem based upon the judgment.
And when you do that,
they might reject it, but that doesn't mean the court's going to let them get away with it.
well, it's an expensive route to go. Better thing
Well,
is
it's not the way to do it. If
it's to go give it to the clerk directly.
I would rather give it to the clerk. I've never had a problem giving it to the clerk.
No, we haven't.
Okay.
I wish you could have helped them.
Well, I wish I could have got it done that way too.
Yeah.
But it appears that the judge recognizes that we have the absolute right to redeem, and we can redeem to the clerk or to the lender.
And I hope they win.
Okay, but the question is,
to some degree,
when was
because
the certificate
also
of sale
though,
done?
I look at the investors out there that we rely on to clean up the marketplace, to clean up the quote unquote fallen fruit or that real estate that has sunk to the bottom, the bottom feeders, whatever you want to call them. We rely on them to do what they do.
It helps
and
it keeps the market moving.
Keeps the market moving. And if you're going to have I sent a wire. I don't,
we tendered redemption funds to the lender. We're not paying off a mortgage. There is no mortgage. It does not exist legally.
I understand the semantics.
That's not semantics.
I understand what you're saying. Do our listeners understand what you're saying?
Well, you're the one saying semantics.
Okay. Explain what that
Okay.
is. What happens to a mortgage when it goes into foreclosure?
When a mortgage is ultimately foreclosed by the judge, the note and
you
mortgage,
got to understand, most people, when you say foreclosed, that means that people are out of the house. That's not what foreclosed means.
Okay, so let's try that again. When somebody goes delinquent and the lender files a foreclosure action, if the lender or plaintiff prevails, the mortgage and note are converted and merged into the foreclosure judgment. They no longer exist as a separate legal thing. Okay, that document exists, but it has no more effect. It is now just a judgment, and the judgment has a foreclosure sale date. And with that comes the right to redeem, or the equity of redemption. And that is an estate in title. It's an ownership right. And you have that ownership right, and it can only be terminated by due process and by the court, by the operation of that judgment, and then the certificate of sale being issued. Okay, when that happens, your right to redeem is over. We tendered enough money based upon the judgment to the servicer prior to the certificate of sale being issued, as far as we're concerned. Okay, we know the amount's right because we tendered about $500 or more over that, and that was the numbers that the attorney filed after the foreclosure sale. He says we're due this.
You use the modified
interest.
number.
Well, I calculated myself, but my number's higher than theirs.
Right.
Okay, and I always build in some wiggle room. But we did it, and they're saying, no, that's not good enough. The judge seems to, well, how can I say no? The statute says yes.
Right.
And they're saying, well, they got to tender to the clerk. And I'm like, no, I don't.
I mean, I agree with them, but I understand your argument. I hope you win.
It's not an argument. But anyway, it's just, it's going to come down. It's going to come down to.
It's not an argument.
No, it's a statute.
Okay.
Okay.
Statute's never been interpreted any other way than what the statute actually means.
Not when it's clear.
Oh, yeah.
Okay. The judges have to use the plain text of the statute. So we have that, but it's going to come down to, and there's emails, and I sent an email to the clerk saying, when were these things done? They came back and said, well, we don't file a certificate of sale till after we get the money.
Right.
Okay. But They didn't tell me when they got the money. But since they looped in the judge into the email, when I responded to him, I had to loop in the other attorney because we can't have ex parte communication.
Right.
And so we're going to see what happens. And the judge has not seen this happen before. So he's like,
I mean, if they just would have time stamped the certificate of sale, this would be an easy argument.
Oh,
an easier argument.
I think the judge would have said, yeah, you were in time and we're done.
I think so too.
And then been no argument. But the question is, we don't have the evidence, and the judge doesn't really want to call the clerk to get evidence for something else, you know. But I think it's the clerk's record,
right?
Okay, you can't really contest it because it's the clerk's record,
right? Which doesn't have all the information.
But that record is what matters,
right?
Okay, and they either have it or they don't.
When's the resolution for sure? When you get?
Well, we have to give our proposed judgments or proposed orders next Thursday. Okay. So we'll see what happens.
Hope you win.
I better.
I'm I have mixed emotions. But listen, I think
that is not the right way to redeem. That's not the safest way to redeem. Okay, because when I take a check in, I know when that was done, and I've never had a problem.
If you have a friend or somebody who's in foreclosure, it's good to get some counsel. It's good to find. I'll put it this way. It's good to get Rusty. He knows what he's talking about when it comes to these things. He specializes in real estate and foreclosures and the like. So just get with him, 904-829-6600, 904-829-6600. Don't ask for him. Ask for his awesome booty-kicking assistant, Dr. Ben, and get an appointment to talk to him. Because had this been done right, this would be a moot point.
Had it been, I don't even know how they came to me, but had they done it earlier, we could have. Rusty, I could have sent a runner.
I don't know where the brain. I almost said fart. That's not appropriate. The brain hiccup came in to where anybody thought they should wire those funds. I mean.
Oh. I did tell you they sent the money back. I did tell you they sent the money back 3 weeks later, which is weird.
Well, but tell them you want an interest on the money.
Well, they're saying, well, so why do they want, they say there's $40,000 in surplus. Why do they want to do that when now they got to pay us the interest and the costs and all this stuff? It's like, if we're right, no, we don't.
Yeah.
Frankly, you send it back. Thank you very much. We'll just keep it. But
they have sent it back.
Okay,
money's received.
I just did not know that, but until today. But anyway,
so
an interesting case.
Where's the line? So, and when you have a foreclosure and you have a servicer, the lender / servicer or just lender hires an attorney to do the foreclosure. In the conventional world, it seems like those two stop talking to each other.
Sometimes. Well, okay.
Most of the time.
What I don't understand is how my client got their wiring instructions. Because he got the wiring instructions. He didn't come up with that, and it's not the attorney that got it.
They're on the statement.
Well, I don't know.
Wiring instructions are on the
on a payoff statement, yes, but I don't know they had a payoff statement.
I think they're on the mortgage statement.
I don't know where they got them.
Okay.
It's weird to me, but it's like he was trying to pay the servicer. If I got the story right, he's trying to pay the servicer. The servicer said, no, you got to pay the clerk. Tried to pay the clerk. Clerk says, no, we can't take it. I don't know what really happened. I just know we tendered the money starting at before 8 o'clock in the morning. I don't know.
But my point is that the foreclosing attorney and the servicer don't speak to each other hardly.
Well, you're not going to get the attorney to say, yeah, we'll take the redemption funds. They're not going to do that because there's more money that they want. Because remember, if you actually pay off from a payoff letter after foreclosure judgment, before foreclosure sale, what does the lender usually do?
Add a whole buttload of attorney fees.
Right, but what do they do? Something they don't understand. They ask the court to vacate the judgment.
I know.
And reestablish the mortgage.
I know.
So they can satisfy
But does it work?
They make more money from it. They don't understand the redemption thing because redemptions don't happen very often. Payoffs do.
We've seen redemptions a lot.
That's because I do them.
We've seen them a lot.
I've not seen anybody else do them.
It's crazy. But if So let's talk about, because in the case, you're hitting on a point I wanted to get at.
Okay.
Because in that case, what you're saying is that if you redeem it, then they just need to satisfy the judgment.
That's right.
But what they do is they vacate the judgment
And then satisfy the mortgage.
and then satisfy the mortgage.
But that's the long way around. It allows the attorney to charge the lenders more money that they can't recover. I mean,
Are you pissed off or just jealous?
no, I like to see it happen the right way. What
So
it
let's
is
talk
a
about-
misunderstanding of what's happened. Actually,
I mean, I can understand vacating judgment. Let's say, for the example, that it's not a redemption, but we're fighting for a reinstatement.
Well, then you would have to you'd have to vacate the judgment and have the mortgage go again.
But we've seen times where the servicer communicates with the borrower,
Directly, yeah.
comes up with a reinstatement. They pay the reinstatement, and the attorney still does the foreclosure.
Right. And it's fun when you have a hearing about that and
Yeah.
you say, did you talk? The judge looks at the attorney and says, did you talk to your client?
Yeah,
And he goes, well, we didn't hear from him. But
right. Because that's expensive when those things happen.
Then they get, it's fun to see the judge get mad at him. I love seeing that. That's fun. Bring popcorn. Okay. When Judge Maltz looked at that other attorney at the hearing we went to, after we said they've been holding a $206,000 since this date, and the judge looks at them and says, "Why are we here?"
What are we doing here?
He just went through the whole it's a foreclosure.
Well, the
trial
funny thing is you knew that whole time, but you had been sitting there just listening and waiting.
because the judge didn't want to hear from me.
I know. What was it, 20 minutes into it?
Well, 10, 15 minutes. They
20?
had to just establish whatever was
Yeah.
due, which is their normal thing when there's a default and there's nobody there. They
Right.
still have to testify a little bit. But now
And
they're
then-
testifying.
and then
Payments
you-
have never been made, and all
And then
this
you
other
step
stuff.
up and say,
We've had this money there for since this
they
date.
accept this money. It cleared our account since this date. Why are we here? That was just too funny.
I mean, that's a fun day in court.
Yes. So on a reinstatement, it's not a redemption, it's reinstatement. What it takes to reinstate is you have to catch up all the back payments,
And pay whatever fees
interest,
they had.
whatever attorney fees they have. And
Right.
you can do that too.
If on the Fannie Mae type loans, the loans that have
Well,
servicing requirements, but
okay.
but if you have a private lender, they don't have to do that.
Yes. On Homestead?
I don't know that there's any law that says they have to. There's nothing that says you have to reinstate.
And now the awkward silence. Are you smoking crack?
Not really, not regularly.
Not at all. Wait 1 minute. Homestead property.
Mhm.
I have a right to reinstate.
Based upon what contract term?
Well, I know the Fannie Freddie has that. built in.
And the FHA, VA loans, all those are there for that reason. They would rather have the payments and keep on going. But if you have what commercial bank has to do that? Once
No,
they-
well, that's not Homestead,
could be.
but it's not normally.
Okay.
So, on a homestead of property,
How about a private loan? I can tell you the mortgages I write, they don't have a reinstatement clause.
so, all right, what causes a mortgage to be in default then?
It depends
Your
on
mortgage.
the words. Okay.
Your
so
mortgage.
The mortgage that I like using the most basically says if you're in default on making the payments on the note.
Which is on the first day
No.
of every month.
Well, if you're 30 days in default.
Okay, 30 days in default.
If it's doing the first, you go
Okay,
to the
but
first
see,
of the
you
next
understand,
month.
when are you in default? 30 days after the payment's due?
No.
Or the second?
On a Fannie Mae note, it says you're in default on the second.
What about your private mortgages that you do?
I think my note says the same thing, but it's a 30-day default. And you don't have to have notice. On a Fannie Mae mortgage, you have to have a notice that you're in default, and you have to be 30 days
But
after you get
technically,
that
the rest
notice.
of the year in default if the payment's not received by the first.
Right. If you go 30
Right.
days in default.
30 days in default, you're in default. 30
So
days
it's
in
doing
default.
the first, you're in
It's not
default
like
on the second.
You're not in default after 30 days, you're in default on the second.
Right.
30 days in default, foreclosure action can start.
Based upon my mortgage that I like to use, yes.
Okay.
Because that's what it
So
says.
technically, you have 30 days
To
when
fix
you're
it.
in default to remedy that issue. If they start a foreclosure on the 15th, as long as you catch up the payments before the 30th day, they have a right to redeem.
Well, they don't have a right to file a foreclosure case first.
Is that what it says?
Well, if the mortgage says I can accelerate and file foreclosure if
30
you're
days
30
in
days in
default.
default,
Okay.
and somebody starts filing a foreclosure case
Before
15
that
days
day.
after
Mhm.
the default, then you have a motion to dismiss.
I
There's no
understand.
reinstatement,
I
just
understand.
dismiss
It
the
was just a
case.
question.
Okay. But, I wouldn't tell any lender not to take the money.
Okay.
Keep on going.
Right.
So, but it's just interesting, some of the nuances that I never considered that a lender would say, oh, we sent the money back when it's a redemption amount.
Right.
And everybody has noticed because I filed a motion or objection to the sale immediately. So everybody had notice of what was going on.
It wasn't like a surprise. The guy didn't start ripping out cabinetry and stuff. The 10 days hadn't even passed.
Well,
so.
right, but the right of redemption terminates when that sale certificate is
Right. But
is
your argument
entered by the
is the
court.
money was tendered prior to that
Right.
certificate of sale being entered.
Right.
But again, a mortgage is in default when it's not received by the second. Another thing that could cause a mortgage to be in default is
Not paying your taxes, letting your insurance lapse.
okay. So what's the remedy there? I don't pay my taxes.
You can be, well, in my mortgage, the
Is
one
that
I
still the
like,
30 days? You have
No.
30 days to redeem that?
you can advance the money and then call it due. But you have the lender has the right to protect the property.
Right.
So, but yeah, you can be in default for just not paying the taxes.
Okay, I don't pay my taxes, and you have until March.
Right, March 31st.
March 31st.
Right.
April 1st. Taxes aren't paid.
Well, remember, foreclosure is an equitable action.
Mm-hmm.
I think there might be an argument.
See, you just said, Rusty, that the lender doesn't have to redeem. This is
No.
why I'm pulling. This is why I'm arguing this.
Right.
Okay. So what's the truth?
It's an equitable action. The judge might go off script and say they paid the taxes after the fact, even after you filed a
But you
foreclosure
could use
complaint.
that same argument on a payment. They were in default. I gave them 30 days. They
it's
didn't
not a payment
pay.
default. Okay. Remember when the first thing you do with a
Default is
foreclosure,
default is default.
right? But you accelerate
I'm
all
just
the payments.
taking issue with your word that says you
Yeah.
cannot redeem. If a lender doesn't want to, they don't have to stop a foreclosure. Once it starts, that's what you said.
They don't have to unless the documents require them to.
Okay. Non-payment of taxes, non-payment of insurance. Even if they fix the issue after the fact, does the lender still have the right to proceed with the foreclosure saying, I'm dealing with a bad apple. I'm tired of the stress. I don't know if they're going to miss their insurance next year. They've already defaulted on the mortgage. Gave them a 30-day notice. Let's even go with that. And they don't remedy it within 30 days. Now I've started the foreclosure action. They hurry up and pay their insurance. Here, you're insured. Do they have to stop the foreclosure?
I don't think they have to.
Okay.
I think a judge might rule against them. It's possible.
Then why not on a payment?
Again,
Do you think a judge would do that? They're 30 days late. And we've had this. We've had some lenders come to us flipping tired of people.
those are
paying.
private lenders, though.
I get it.
Not
That's what I'm
institutional.
trying. That's
the
what
private ones can, if they say we're done,
That's what I'm talking about.
okay,
Private lenders. Okay. They're done with the person. They've been late. We give them notice. 30 days. I'm starting a foreclosure. They quickly come to me at the cashier's check and says, here, take my payment. Matter of fact, here's next month's payment.
yeah, I don't think so.
You don't have to stop the foreclosure.
I'm saying you don't have to stop the foreclosure, but I'm also saying that the judge may make an equitable decision,
Okay.
and that could. So you want to be, you want to come out ahead in front of the judge, especially after you spent money filing a foreclosure case.
Right.
The note that I like to use specifically says that if if borrower does not pay the full amount of each payment when due, or fails to keep any promises made in the security agreement,
which is
mortgage,
insurance and
the
taxes.
mortgage, yeah,
Okay.
then borrower will be in default without notice.
Okay.
And lender may require borrower to pay immediately the full amount of principal which has not been paid and all the interest that borrower owes on that amount. That's my default clause.
Point blank.
Pretty simple, right?
Right.
Simple's easy.
But a
Yeah.
judge may say, hey,
Right.
it would be equitable for us to allow them to reinstate.
Right. So now
Okay.
the mortgage that I like, the commercial mortgage I use, if borrower fails to pay taxes, assessment, water, sewer, whatever, uh, or fails to comply with the obligations under the mortgage, the note, or any other document, the lender at its election without notice to borrower has the right to make any payment or expenditure that the borrower should have made or that the lender deems advisable to protect the security. Any payment will not prejudice lender's rights or remedies under this mortgage, which means you paid it, so it's not due, so we're not in default. No, that doesn't affect that.
Okay.
And then that becomes money that can accrue at 18%. And then when there is an event of default, which is payment, okay, all the other stuff, they have the right to foreclose.
Okay.
Okay.
All right.
They can file it. They accelerate, before you.
But you think that in a case of a lender who is just fed up with the borrower, they want to foreclose, the borrower comes to you and says, defend me. I have a cashier's check. They won't accept it. Let's take them to court. You think they have a chance?
I would enter the case if I had that cashier's check or the money in my trust account. Because what typically happens, the lender or the plaintiff made all these mistakes. Okay, so where's the money? You got to say a pile of money sitting to pay them current,
and there's
nobody does
in
that.
this story. There's no mistakes. It's just that they got behind. Somebody got sick. Whatever the issues are, but they have a cashier's check. They want to reinstate the mortgage. The lender says, "Screw you. I'm tired of dealing with you. I don't like you anymore. No, I'm doing a full foreclosure." Borrower comes to you and says, "Rusty, represent me. Force this lender to take this check." Do they have a chance?
I think
Take them to court.
Well, you're defending. You're not taking them to court. You're just defending.
Okay.
Because I'm not suing them.
That's true.
Okay,
You're representing them. Sorry.
Right. I would not guarantee a result at all.
So attorney of you.
Well, I guarantee my best effort in death. That's all I can guarantee.
No.
Okay. But my mortgage says if any event of default occurs, the entire unpaid balance, principal and interest, and all the other stuff, we immediately do unpayable at our option.
Right.
And without notice or demand.
Right.
Okay, so I can just file.
Right.
Here, this mortgage that I'm looking at doesn't even take 30 days.
Okay.
Okay.
So it's late on the second, I can foreclose.
But
well, you have the 15 days before the 5% penalty, or
whatever.
Is that even relevant?
Well, that's not.
That's just a penalty.
That's just a late charge.
Yeah, that's just a penalty. Okay.
We call it a late charge or liquidated damage. We don't call it a penalty. Penalties are not supported in
Normville. We in Normville do.
I'm just doing my best to fix the thing over time.
We in Normville do. Okay.
Okay. But anyhow, it's some of these nuances do not come up very often.
Yeah, you say that. They've come up a lot.
I mean, we do several redemptions every year.
Well, as the market tends to
market's changing,
continue to fluctuate, as the trends are, I guess I should say, we're trending in an odd place. We're trending down as far as values are concerned.
Values are going down,
and we're seeing a little more foreclosures.
It's going to happen, yes.
So the value is not always going to be there. With these interest rates at 3% or whatever they are, that these people are running into real life problems. They miss a payment or two or whatever. It's important that they have the right to redeem, because to replace that or to rent something with these lower interest rates, they won't be able to match it. So redeeming, or in the case of reinstatement,
reinstatement would be very vital, because you're getting back what you had.
Right.
You're no longer in default because
you go back to the interest rate you had originally.
Right. Now the Fannie Mae and those loans, the interest rates do not accelerate to 18%, but on a lot of the other ones, the privates and commercial loans, they do.
Right. Is there any prohibition on homestead property for that?
Not that I've ever read.
Okay.
Again, remember Fannie Mae, the Fannie Freddie's, it's meant to be a uniform thing, and where investors they can rely on what's going on, and it's there to help people buy. The whole reason for Fannie Mae as a quasi governmental type thing is to help people buy houses.
Right. Standardized things too. I don't
Well,
have to get an attorney
standardized.
on every purchase.
Right, but
The forms are standardized. They're the
right,
same.
and like with an FHA loan, before they can foreclose, they have to offer you a counseling, credit counseling.
Right.
Okay, if they don't, that's a defense. So that the purpose of those loans is to keep people in their homes.
Right.
Okay, with your privates and commercials, they don't have to do those same things.
Now I'm going to give you a heads up to next. Well, it's not next week. It's going to be the following week.
Mm-hmm.
We're going to talk about contracts.
Real estate contracts.
Real estate contracts.
Oh boy.
Assignment of contracts. Those types of things. But I want to hit on something. And we've talked about this briefly. And for whatever reason, I like revisiting some topics. And I like revisiting some topics because I feel like I've got to refresh my mind. I get done talking to you, feel secure about what we talked about. I agree with you most times, but other times I don't. But for some reason, these questions keep surfacing about going under contract on your primary residence, that if you change your mind, there's an out. And I saw that look in your face, so I know
Based upon what?
Well, that's the interesting point. There are realtors in our community that believe you cannot force grandma to sell her home. If she signs a contract and then later on, week before closing, everybody's approved, buyers followed crossed their T's, dotted their I's, they're doing everything they're supposed to do. Grandma says, oh my goodness, my sister who I was going to live with has passed away, or their house got foreclosed on. I have nowhere to go. I'm not selling my house now.
We're giving you a pile of money.
I'm not selling my house now. Force me.
Unless there's a contract provision otherwise, or statute that just popped up I've never heard of.
Well, I'm going to give you some time to look into it. You got 2 weeks.
Okay. Well, I can tell you that, number one, real estate is considered unique. There's no other piece of property like the one grandma has.
Right.
Okay. Because and it's not like a pen that you can get from somewhere else. It's not fungible material. It's not like buying a car. You can't get a
those
different
words
one.
again.
That's one of them
Fungible.
$50 word for.
We don't have Julie in here, but we've already verified that word once with you.
Okay.
Fungible.
Yeah. It's not like it's not a pen. You can replace it with something else that's unique. When something is unique, we typically can enforce a contract by specific performance. And you can get a judge to order specific performance.
Can order grandma to the curb.
Can order grandma to go to closing.
And
or
grandma
make
doesn't
somebody
show up.
Well, then you could probably get a special master to go to closing for her.
We've seen that.
Okay.
It wasn't homestead, but we've seen that.
Right. But even your homestead, if you and I own a piece of property together and we inherited, especially, and I'm living there, we both own it. So I have homestead exemption. If you decide we need to not own it together anymore, you can force the sale or make me buy it from you. But if you force the sale and I don't buy it, then
you're out.
Then my homestead property goes bye-bye.
Okay. I want people to know this. There's this impression
that
a contract is just
because
I don't know where they're getting it from.
Okay.
I will tell you this. When I was teaching one of my classes,
mm-hmm.
I had the realtor say I was talking about the importance of contracts and talked about some of our experience where we've actually had sellers remorse and tried to walk away and they were forced. But I never had a specific homestead. The agent said, well, that is applicable except for homestead property. And I was like, I don't necessarily agree with you on that statement. I would have to investigate that. But I said, where did you hear that? My broker. So it's just one of those things where people somehow believe that there's an out for them. If something changes substantially, they got some kind of exit clause, which brings me to the point how important contracts are and how important all the nuances of these contracts are. And so I want to talk about that. Well, some of the other things.
I can tell you from the as is FAR contract.
Mm-hmm.
If for any reason other than the failure of the seller to make seller's title marketable after reasonable diligent effort, seller fails, neglects, or refuses to perform seller's obligations under this contract, buyer may elect to receive return of buyer's deposit without thereby waiving any action for damages resulting from seller's breach, and pursuant to paragraph 16 may seek to recover such damages or seek specific performance.
And specific performance defined is
The judge makes you perform on the contract, which means you're going to sign a deed. You got to go to closing.
The liability of a buyer who doesn't come to closing and decides not to buy is only maxed out at the earnest money deposit that they have.
If buyer fails, neglect, or refuses to perform, including the payment of the deposit within the time specified, seller may elect to recover and retain the deposit for the account of seller as agreed upon liquidated damages,
right?
Consideration for execution of contract and full settlement, whereupon buyer and seller may be relieved from all further obligations. Or seller at seller's option may pursue paragraph 15 to proceed in equity to enforce seller's rights under the contract.
Now, we had a situation with a gentleman that we know very well. I don't remember if you remember that. I don't want to say the name. First name starts with a G. Last name starts with an M.
Okay.
And he was under contract to buy a piece of property. He walked away. For some reason, the terms of that contract actually made him liable for walking away.
Well, if the property value goes down.
Yes.
Okay, because
they sued him for, this is back during the crash.
Okay.
They sued him for the value that was lost under the terms of the contract. They settled for less money. They sued him. They won.
As well they should.
Yes, but is that what our FAR bar contracts allow for?
It does,
Okay.
but you can agree to take liquidated damages of the deposit.
You can, or you can seek for the damages.
Well, listen to this. A couple months ago, I had a trial on a deal where the contract, the buyer backed out. They had a 10-day due diligence period and was a large sum of money. They had a $15,000 deposit. They backed out after the due diligence period expired. And the contract required at the end of the due diligence, they had to pay an additional $10,000 deposit and everything was hard. Okay. They backed out based upon their theory of square footage. And when we went to trial, I went after not only the deposit,
but the other deposit
sued
they
me.
should.
They sued, they
sued you for the deposit.
Yeah, they sued us for the deposit, but I countered with, not only do we get to keep the deposit,
but you got to give us the other deposit you should have given us. Right.
And I won.
All right. So contracts
mean something.
Okay. Contracts mean something. We're going to talk about that more in 2 weeks. So hopefully you have some good notes. One other thing we want to talk about is property being sold that has a lease on it. We also want to talk about some of the fraudulent, like title lock and those things that people are trying to sell to help protect someone's interest after they purchase a property from being sold out from under them. Which I say that loosely because can a person lose their rights if somebody conveys a fraudulent deed?
A fraudulent deed conveys nothing.
Right. No. So, and we'll talk a little bit about that if we have time. So those are the things we're going to talk about.
But what happens to the innocent buyer?
They get title insurance.
Right.
They,
but what happens if, here's the thing. If the property appraiser sticks you on the stinking tax roll and you pay taxes for 7 years, and the person who owned it didn't think, why didn't I get a tax bill for 7 years?
Right. No, you
can sit on your rights.
Yeah.
But
the seller would lose
outside of that, because there's a color of title, even though it's a fraudulent deal. See, that's the problem. It's not really a color of title.
It is, Rusty. Save it for, we're going to talk about this. And again, I understand we've talked some about this before, but we're going to revisit this topic. Okay. How do people find you?
904-829-6600. Talk to Ben.
That's
because if you try finding me, I might be with somebody.
That's true.
And I try not to interrupt that.
Rusty's been practicing law for how long now?
Next week it will be
that long.
17 years.
Is that crazy? Seems like
Absolutely
yesterday,
nuts.
doesn't it? I remember we were talking about that, and you drew the short straw.
Well, you know,
There's way too much fish.
I had 2 years worth of college down, and you wanted to fish.
Yeah, I did. So, but we're glad Rusty's with us. Rusty actually practices law in our building. It's great having access to him. We're Land Title America. We've been in business for a long time, but I opened my company back in 1997. We've been around in this community for a long time. We do real estate closings, refis. We help with people's purchases. We're very detailed in protecting your identity, making sure that you're the one selling and not somebody else. So we do all those things, and we have a great staff. We are what I call a title company that does closings, and that matters. You don't necessarily want a closing company that writes title insurance. It's a little backwards. So we'd love to help you. Keep us in mind. You can find me at 904-797-9600, which is the office number, or you can reach me 24/7 on my cell phone, 904-501-4481, 904-501-4481. And this has been Land Title Talk. We appreciate you being with us. We'll see you.